following program is classified G. It's suitable for all ages.
Tonight, we take a look at the contentious presidential pardon. Sri Lanka's constitution empowers the president with the authority to pardon convicts. Views have varied on providing this authority to the executive. The critics of the presidential pardon have suggested that a mechanism to keep the power in check is important. The contentious topic was reignited when President Gotabaya Rajapaksa bestowed the presidential pardon on former parliamentarian Duminda Silva. Many questions have arisen as to what the core constitutional provisions and limitations are in granting the pardon. Welcome to Law, Land and Liberty, where we discuss the legal questions within society as of now and the most pertinent one within this week. And to do just that, we have within us a topic that has been within the public for a long time, which is pertaining to the presidential pardon, the executive pardon. And to discuss that very same factor, we have brought to you an individual who is not unfamiliar to everyone. He has been with us within the legal field for quite some time, a renowned name within the legal field, and he's not a new person to come to Derana. Professor Prathiba Mahanamahewa. He's the former Dean of the Faculty of Law at the National Technology University of Jamaica. He's currently a Rector at the University of Colombo. That is two within the portfolio, within the large portfolio. So that is how we will recognize you today. Before we get into the discussion, just to give an outline of how we are going to take this forward, we're going to start with the constitutional provisions of the pardon, give you a breakdown of that, move to the remedies and limitations, move to how this is present within history and within other countries, how the executive pardon is present, and finally take a look at the checks and balances between the governing bodies within a country.
Hi, I am Derana. I am a law student. My question is, what are the provisions in Sri Lankan law for the presidential pardon?
All right, let's get into the discussion, starting off with the constitutional provisions. Professor, now this topic, a lot of people have been having their own versions and their own discussions of what this actually means. So we need to get the experts take the real legal way, because a lot of scholars also seem to have a different opinion when it comes to this. How does the Sri Lankan constitution portray to us the executive pardon? Professor, how do you see it?
Straight away, I will go to 1978 Constitution. 1978 Constitution, 19th Amendment and the 20th Amendment also very important. Before 19th and 20th Amendment, President can pardon, and also the pardon is not subject to any limitations or any reservations. But if you see the 20th Amendment, 34(1), the President may, in the case of any offender convicted of any offence in any court within the Republic of Sri Lanka, 34(1)(a), grant a pardon either free or subject to lawful conditions. That means full free, even the civil rights abolished, even with that conviction, it can be free, or subject to certain lawful conditions. Then B, grant any respite either indefinite for such period as the President may think fit, the execution of sentence passed of such offender. Third one, substitute a less severe form of punishment for any punishment imposed of such offender. Now, for example, if death penalty given, it can be sentenced to lifetime imprisonment also. And then remit the whole or any part of any punishment imposed or any penalty or forfeiture otherwise due to Republic on account of such offences. Sometimes there are cases in Sri Lanka, we have seen even municipality council chairmen, when they are failed to pay the taxes and others, it has been fully given free. But these were there before 19th and 20th Amendment, but 19th Amendment added another clause for this. And 20th Amendment also didn't change that, it go as it is. Now, provided that any offender shall have been condemned to suffer death by the sentence of any court, the President shall call a report made it from by the judge who tried the case and shall forward such report to the Attorney General with instruction, and then it goes to the Ministry of Justice. Now here, even a pardon given or intent to give a pardon, there is a procedure given. Now this procedure, mandatory or non-mandatory, is another issue. I am not going to argue with that. So here, precedent that where any offencer shall have been condemned to suffer by the sentence of any court, the president shall call a report made to him by the judge who tried the case. Now, for example, if the judge is not living, then from where the report
should come.
That is the biggest problem. Later I will explain to that.
All right. Yeah, we can talk about that more in the limitations.
So these are the legal
provisions that are.
So I think the 19th Amendment little bit busy on that, but they could have changed. But even the new constitution coming very soon, you can think about that. Right. So these are the provisionals in the constitution, 34(1).
All right.
And also, if any party is not happy with that, 35(1), there is a remedy.
We'll talk about remedies within the next segment itself.
Sure.
Professor, just to get a clarification here on our first segment itself, I just want to ask you, Supreme Court will be the authority that will be dealing with this if there is an issue with the procedure, or if there is, will the Supreme Court have the authority to do so?
Now I can give some examples. Even in United States, when a president give a pardon, even the Supreme Court has not gone much in itself to check the president pardon, how he had granted it. It can be a self-pardon. I'll explain the USA procedure later, because we all take USA Constitution Supreme, right? So in that case, I can give the ability of a president to pardon or self-pardon has never been tested in courts in United States. Because United States, Donald Trump had given pardon to 137, and Obama period, it was President Obama period, it is 450 plus, like that. So here, it's very clear. Now the Supreme Court, if they want to look into this, someone has to send a petition. That petition come under 126, Article 126, violation of the fundamental right to equality. Why you had granted for this prisoner A or B, and why not for me? So that's why 35(1) is very, very clear. If any person is unhappy with that, what he can go for a fundamental right violation application. Now there is a case filed. Former President, Honorable Maithripala Sirisena, given the pardon for the Royal Park murder case, Mr. Jayamaha. So that is, it's in the court. But I have seen in other jurisdiction, even in the Supreme Court, they have not gone much lengthy on that precedent decision, whether it's a self-decision, whether it's a referred decision. So that is a situation in the other part of the world. So we have to see cases not before 19th century and 19th Amendment. After 19th Amendment, we have only one case, so we have to see into that. But nothing mentioned here with regard to the interference of the
within the Constitution. All right. I think our first segment, we really wanted to get the constitutional provisions, and the professor put it out really well. I want to take a break and go into remedies and limitations so we can really take the discussion forward from that point onwards. We'll take a very short break. We are with Law, Land and Liberty. Stay with us.
And I'm a law student. My question is about remedies and limitations. Are there any remedies and limitations available for the presidential pardon?
Welcome back to Law, Land and Liberty. We are in conversation with Dr. Prathiba Mahanamahewa. Doctor, our next segment, we are going to talk a bit about the remedies and limitations that are available within the Constitution, and you really put into context the procedure that has been laid down. Now, questions rely on, and you mentioned that there are limitations within that itself. If the judge is not alive, that would be an issue. How should we read that process? What are the remedies that are available? What can we take sort of from the precedent that is set from the cases that are currently in court?
Now, this is a legal power, and when President implement this, it is also legal. 34(1) very clearly say. The only thing, however, it must be referred to the trial judge or tried judge and the Attorney General, it is also saying. That is the provision here. Now let's see another inmate or another offender in the prison. If we feel that justice had not met for him. So there is a section 35(1). He can also challenge that in the Supreme Court. 35(1) is basically immunity of President from civil or criminal. For any civil or criminal, you can't try or sue. Now, for example, this 35(1) clearly say, if a violation happened from President, then you can go for a fundamental right violation application, that is within 1 month. After that, if we think so, it's clearly say that the respondent, you have to name Attorney General. So, Honorable Attorney General's name, you have to file that case. So, that is also available. So, in this Constitution, 20th Amendment, which is now a part and parcel of the 1978 Constitution, 34(1) President pardon, and then President immunity also there, that is 35(1). When you come to 35(2) and 35(3), even fundamental right violation, if happens so, if someone feel that is rights violated, then that is the remedies there.
All right. Something that I want to clarify there itself, you mentioned if another, the protection is available for the President within the Constitution, no one can file a suit against him when he is within office. If another person believes that the Attorney General should also, because the Attorney General also should give his view when it comes to providing some sort of view to the President. Now, something that is in, firstly, let me ask you this. Should the President declare all of this? Is there a requirement within the Constitution that says the President should declare that he went through this entire procedure, that he has summoned this entire process, or is that something?
Nothing mentioned.
Nothing mentioned.
This is where the power with the President. Right. So the President or the President office refer these two things. And even it never say you must publish this. Exactly. So even this can be questioned in the Parliament. But even in the Parliament, President is not bound to disclose all these things. So that is a process where, so if the public is interested, then they can get a clarification. And also the other thing, under the Right to Information Act, even this, if it is, basically important for the whole society, public interest, then they can check with that.
That will be also be filed against the Attorney General, is it?
No, it is not against Attorney General. If someone feel he want to get the information as a public interest, but on the other side, if it is a private one, nothing given, public interest, then you can ask.
It leads me well to my next question on this segment, Professor, on the other associated legislation to this. Is there something that we should know now? You mentioned the right to information.
Yeah.
Is there anything else that is there involved with this specific article within the Constitution as per, because if the President is protected, like my following question, like the next one was going to be on whether people within prison, whether offenders are allowed to bring in a President saying, okay, the Attorney General in this scenario did give the recommendation to the President. Why is that not happening in my scenario? Can that happen? Is that something that
in
is
the
possible?
world, it has never happened. Even in USA, Richard Nixon, he lost because of the impeachment. Now, against the impeachment, you can't give the President pardon, but it was given. When it went to Supreme Court in United States, the Supreme Court never went into the, legality or whether this was within the constitutional provisions, they never checked that. So if someone feels, let they proceed with that.
Right.
So that is their right. So I can't give anything beyond this constitution. Within the constitution, it never say, when a president pardon granted, you must, otherwise you can't grant the pardon. But it is nothing like, not only in Sri Lanka, other countries are also there. So specifically, if you say 13.4, 1 A, B, C, D, and provided that you must refer to the trial judge, and then you go to the Attorney General, those things are there. Other than that, whatever you asked, then there must be some Supreme Court guidelines, or even now when President Councils are appointed, then Supreme Court gives some guidelines. No? So such situation has not arisen. Or it should come with the Supreme Court rules. There are certain Supreme Court judgments, but they are, even in the Constitution it was not there. That's a best case, Sriani de Silva versus OIC Payagal, when the right to life was given. So you must see that. So I think the Supreme Court can apply, if anything happening like that, Supreme Court rules are there, then Supreme Court can make guidelines.
Right. I think that clarifies a lot of doubts, I think, that was present. Probably just to clarify just one more thing, because we see this coming up within society and within the public forum. Yeah. There people selectively criticize sometimes. They mention, okay, pardon given to these people is considered okay, pardon given to this particular figure is not problematic. As I think you did clarify this, but just to get a proper clarification, the president is not bound to answer those questions, is it? Or the president doesn't have to, within the constitution, how is it mentioned?
Now if I see, to answer that question, I have to go away from the constitution. Okay. Whatever you ask is not legal, but I'll give the answer. It's a socio-cultural one, rather than legal. So it basically for the president. So now, if I give a good example for that, even there was an allegation, these LTT prisoners who was tried under the PTA Act, long time they have been kept. But this time 16 prisoners were released. And earlier war heroes were released. So time to time, so no one is going to question that. No. So selective or non-selective, it's a duty, that is where president is looking. Now even immediately this pardon was not granted. You have to, you have to write you have to write to the prison commissioner, he will give a reference. Like that the file goes there. Right. So my argument is where selective or non-selective, then you have a remedy for that. Now let's see some person think, yeah, it's a selective one. Why I was not? Then you have administration and executive action. Yes, it's executive action. Let's, fight for your rights.
All right. I think that really puts into perspective this, a lot of questions answered there even for me. Professor, let's take a very short break and we'll come back and we'll talk about the other constitutions, the history of this, the context that we are in. But before that, we are going to go into our special segment. We have Anuradha Wickramasinghe to bring you the situation within the legal field within our country. Here is Anuradha Wickramasinghe with Law in the Land.
Thank you, Danidu. This too has been an eventful week in the legal field. Let's take a look as to how the law has worked in our land. The Ministry of Justice held a briefing for the diplomatic missions and international organizations in Sri Lanka on the MV Express Pearl disaster. The briefing was jointly held with the support of the UN Resident Coordinator, Ms. Hana Singer. The briefing covered many key areas such as the present efforts to minimize dangers, the effect on the fishing community of Sri Lanka, preparations for a potential oil spill, and assistance and technical support that can be given. Meanwhile, co-cabinet spokesman Minister Keheliya Rambukwelle announced that 8 international law firms had expressed interest in assisting Sri Lanka in the case against the owner of the MV Express Pearl. The Cabinet of Ministers had to decide to appoint a committee of senior officials to select the most suitable institution. Minister Rambukwelle said that the Attorney General had filed a case at the High Court of Colombo against the owner of the vessel, the captain and the board of directors of the local agency. Meanwhile, P&I Club, the insurer of the ship, has agreed to pay Sri Lanka Rs 720 million in compensation for the fishermen. The Advisory Committee to the Ministry of Justice on Reform and Review of Family Law represented its report to Justice Minister Ali Sabri. The report of the 12-member committee chaired by Kushandi Alvis, PC, includes recommendations on marriage, divorce and children. Key recommendations proposed by the committee include that the dissolution of a marriage can be obtained by either party to a marriage and to safeguard the interests of children by not letting them be treated as an extramarital child despite a decree of nullity of marriage. The Attorney General informed the Supreme Court that indictments have been filed in the Colombo High Court against former Western Province Governor Azad Sali in connection with the controversial statement he made on the 9th of March. Deputy Solicitor General Dilip Piris, appearing for the Attorney General, informed the Supreme Court that the indictments were filed against Azad Sali for committing offences coming under the Prevention of Terrorism Act and International Covenant on Civil and Political Rights Act. The Supreme Court has imposed a 6-month suspended and imprisonment and a fine of Rs 500,000 on an individual who has infringed the copyright with regard to a music record containing songs sung and owned by veteran musician Nanda Malini and lyrics composed by Professor Sunil Ariyaratnam. At the end of the trial, the accused was sentenced to a term of 6 months imprisonment, suspended for 10 years and to a fine of Rs 500,000. That was a look at the major events of how the law had worked in our land. We will now go in for a short commercial break. Join Danidu on Law, Land and Liberty on its next segment shortly after.
Hi, my name is Naveen Avinash and I am a medical student. So my question is about the history of the executive pardon. What are the key parallels of the use of the presidential pardon both locally and abroad?
Welcome back to Law, Land and Liberty. We are in conversation with Dr. Prathiba Mahanamahewa. Professor, you answered a lot of questions. You gave us categorically the provisions that are present within the Constitution, and I think that really sheds a lot of light. Now, Professor, just to move away and to look at the bigger picture in this scenario, I want to ask you, now with your experience, given that you have understood academia outside Sri Lanka as well, how do you see this functioning within other countries? Because this question has been asked possibly in every country, even within our neighbor India, it's been placed within the Constitution, even as you mentioned within the United States, where we follow some of these judicial systems. We'll take some time on this segment also, Professor. What exactly is the situation on the ground? I want to then go to parallels we can draw with previous pardons that have happened, but firstly, what is the situation both like locally and foreign?
Now, let's see United States. Now, USA Constitution, Article 2, Section 2, Clause 1. That is very clearly defined. The US President can give a pardon to any prisoner for any type of offense other than impeachment offense if someone has been punished. That means they have the state law and the federal law. That power granted by the Constitution of that clause to the President. Then how we proceed, that is very important. That's why you ask. So any person feel that he need the presidential pardon, he will write to the office of the pardon attorney. Now Sri Lanka we don't have.
Oh, okay.
In USA they have an office of the pardon attorney.
Is the President bound to only consider people there?
Let me explain. Yeah. So the office of the pardon attorney then give the reference to the US Department Justice for investigation and review. Thereafter, the answer to your question, yes, then the President will review it and the President will decide. But that has been bypassed in several times. Now, for example, in the Obama period, a double murder, a taxi driver, was given the pardon. And sometimes I have seen they take the DNA test. It can be a wrongful conviction. That's why India is there. Indian Constitution, Article 72, the President can give the pardon. But it is not a privilege. In the Indian Constitution, it clearly says not a privilege, but as a performing the duties. In that, it clearly say on humanity grounds or grace. That means India also it is working. Now, ground level I can tell, even the death penalty is a torture. United Nations Human Rights Council, if you see all these 1966 Civil and Political Rights Convention, Protocol 2, what it say? Abolition of death penalty. They all condemn death penalty from the world, or convert to life imprisonment, or if the prisoners have served some term, then they give pardon. So in UNHRC also clearly against the death penalty. But sometimes they selectively take countries. True. As the question you ask, selectively. Why Sri Lanka, why not other countries? We can also ask like that. I am not going to argue that. In Canada also same. Canada, the pardon is given by the Governor General. He has all the powers. And also there can be some references. As Sri Lanka Constitution, it must be referred to the tried judge as well as the Attorney General for the reference. Now in some countries they go with the Supreme Court, retired Supreme Court judges. They have appointed retired Supreme Court judges and they get the reference. But the president is not bound by that. So the president can check. And the retired Supreme Court judges, they give a report, yes. In United Kingdom it has happened. Even after the death penalty was given, after the capital punishment executed, a prisoner had formally applied, but at the time when they were checking, it was too late. To clear the name of the prisoner, the president pardon was given. In USA, even before you commit the crime, or after you commit the crime, or in the process any place, this pardon is given. I am not supporting for this pardon. I am telling the procedure. So don't take me in a different
Exactly. No.
So what I say, I clearly clarify the world constitution. More than 137 countries, the president pardon is there. Let's see Gulf. In the Gulf region, you know poor Rizana, she was given the death penalty. She appealed. Our ministers went and appealed from the government. What the sheikh said, no, I can't give it. According to our law, the pardon should be given by mother and the father. Mother and father means the child died. They say it's a murder. Father said, yes, I'll give. But mother said no. Then she was given the capital punishment, only 18 years. So likewise, many countries, it can be president pardon, it can be prime minister pardon, it can be governor general pardon, it can be the victim's pardon also. So we are now in a good, junction, because the new constitution is now going to introduce. In such a situation, we can see more clauses you can propose to the committee how this should implement.
A sort of evolution to this entire process.
That's right.
Yes. Professor, I just want to touch on this.
But Sri Lanka, if incident happen, only these things we take into big picture. So I feel not only one, in future also, you can give the
before these situations arise.
Yes,
Professor, I want to ask you now, you did take some very good examples. You took United States, who still in certain states has the death penalty. Is the presidential pardon used in those scenarios or in other countries as a way to mitigate the effect of a death penalty, where they actually kill the person within office? We don't do that in this country. So is that the reason why it's there in other countries, or specifically within the United States? Is that how it evolved?
Excellent question, excellent. I have seen this in Geneva, United Nations Human Rights Council sessions. Yes. So what they are doing, rather than executing the capital punishment, they convert that to a lifetime imprisonment. Now, once you convert into a lifetime imprisonment because of his good behavior and take into other reasons, then the president can give the pardon. Now, even that, I have seen in Sri Lanka some 70 years old, 8 years old. Last person was hacked to death 19 76. After that, we have not executed because of this human rights issue. So these people are very old and they can be released, because I am not supporting, I am human rights activities. Therefore, I am not supporting even to execute them. So most of the countries now, they go with that approach. Now I'll tell one thing. Now the High Court give a punishment, let's say 20 years. Do you think that prisoner is serving 20 years in prison? No. Prison ordinance. Vesak Poya Day, you will get some free dates. Other Poya Days, you, because of your good behavior. And finally, so no one is checking that. So the judge has given 20 years. Sri Lanka, we are not post-reviewing these judgments. All right. Has anyone asked, oh, the judgment is given for 20 years, but now he came out of 7 years. Not a pardon given. That they recommend to release those prisoners to the president sometimes, or even their term ending in that way. So when you go to prison, what will happen? Whatever the punishment given by 10 years or 20 years will be shortened. So there are other laws, that's why you asked, not only in constitution, or even you can get some information from right to information, but there is a prison ordinance also. So we have to gather all these things. Reforms are needed at the moment. So you can talk about reforms. But only thing, the president decision or whatever the decision took by the president has not been questioned in any country, in any courts, even in USA. So even the courts in USA, they look, all right, it's the president decision. So therefore, we are not going to intervene.
All right. Multiple questions come to my mind, Professor, with the little time I have.
Sure.
I want to clarify some of them with you. Professor, are there any parallels within Sri Lanka that we can draw back to where this happened, where it was questioned before? I think just to bring light to those.
Definitely.
Yeah.
That's a good question. Now in 1972 Constitution, I can remember when Minister of Justice was Honorable Felix Das R.D. Bandaranaike, even the President can give the pardon. What the Justice Minister did when the appeal or when the requesting for release come to the Minister of Justice, he appointed a committee. Additional Secretary of the Minister of Justice, retired Supreme Court judge, a journalist, a principal, likewise. Then those 5 committee members, this was revealed to me by Professor Karu Hangavatta, now a professor in Nevada University, USA. He was the additional secretary at that time. He said, they go through the file and thereafter unanimously, they make a reference to the president,
Right.
nominal president, not the executive president. So that is a good example where we can take. Even that is not in the constitution, but the minister has taken steps to introduce
That
this.
President is available.
Yeah. Sri Lanka 34(1), that part is there now in the constitution. Still worry the tried judge.
Right.
If he is not living, what will happen? That's my only question.
I have a few more things to ask you on that front, Professor, but we have to take a very short break. You are with Law, Land and Liberty. Stay with us.
And I am a law student. My question is about checks and balances. What are the key checks and balances present between the judiciary, executive and legislature?
Welcome back to Law, Land and Liberty. We are in conversation with Dr. Prathiba Mahanamahewa. Professor, we are in our last segment. We want to, I interrupted you in between most of the segments to get in like the direct message pertaining to what is mentioned within the Constitution. Professor, just elaborate on anything that you wish, but our last segment is going to be on the checks and balances that are present between the executive, between the judiciary, because we have read that in certain situations that the pardon is given to the executive authority to have some form of check and balance over the judiciary at one point. And we really spoke about this within our third segment as well. Where I did interrupt you, Professor, before was when you spoke about precedent. And you mentioned what was happening within our country, Professor. Anything else that you would like to add on that front?
Yeah, now let's see 1978 Constitution. The drafters specifically incorporate this into law, grant of pardon. But not only that, 1972 also I earlier explained how the system operated. Even the president pardon implementing the procedure or even references were not there. But what happened? The Minister of Justice itself introduced that system. If you go to 1947 Constitution, Salisbury Constitution, that also the Governor General had that power. But even the Governor General, there were some cases when the cases were referred from the prison. At that time also on humanity grounds, on family issues, they have considered when the term was completed for a certain time. Now, if it is the death penalty, that is the execution. But until that it convert to lifetime imprisonment, not had done. But if that is happening, now presently we have seen these prisoners in Mahara and other prisons, they were, having a...
Writing.
Yeah, that's a strike or hunger strike they were having. But their demand also like that. So convert this into a lifetime imprisonment. They know from the lifetime imprisonment, getting a release is not much harder than the earlier situation. So in 1978 Constitution, when Honorable J.R. Javadana, when the first set of prisoners were released, 1971, those who were in the insurrection and fighting against the government, they call that a revolution. But on the other side, the Janatha Vimukti Peramuna JP leaders were released, and hanging on to that, another person also committed a different type of offences were released. So likewise, every president in Sri Lanka, even Honorable Chandrika Bandaranaike Kumaratunga, even former President Mahinda Rajapaksa, they have all operated this and used this, but not as a privilege, but as a duty. Sometimes you can take in USA Constitution or even in the Indian Constitution, they never say it as a privilege. And recently we have seen former minister, now a parliament member, Honorable S.B. Dissanayake. So likewise, we have seen when they write to president, they look into that properly. Now in the case where you ask executive, legislation and judiciary, there should be checks and balances. So that's why rule of law, no one can challenge. It is unchallengeable. So the constitution is the top. Now if I give another case, before 19th amendment, there was a case called Water's Edge case. In that case, what happened? No one can file a case against president on civil law criminal matter. There was nothing like this in the 19th amendment at that time for the references. Honorable C.J. Sarath and Silva at that time said, the constitution, the top is public trust. If someone has violated the public trust, even the president you can sue. So the former president had to pay the damages also. So every time we have seen the president's action have been challenged. Even in a election period, they were not allowed they came from uncleared areas to cleared areas that were not allowed to go and vote. So when one organization went to courts and one journalist went to courts, yes, president action had been questioned. So nothing to worry about this. Mm-hmm. Now even in these cases where I have mentioned, criminal and civil cases, the immunity is there. Even that, a person can go and challenge, but leave to proceed, come with the thereafter.
Right.
And also, we have to see in a very humanity grounds, even the death penalty given in many countries, I have seen, there were some wrongful convictions also. In those wrongful convictions, I am not challenging or I am not giving a defamatory statement. These were happened in other countries. So in those cases, what happened, once they refer to separate committee, they look into that. In one case, I can remember that also in USA, where the lawyer's fault was there, and given certain, submissions, they were not parallelly acceptable. But later, this case was once again. Now, this is where the judgment is given to release the prisoner and acquitted. In that case, what happened? The Attorney General once again appealed, and he was given the death penalty. So, likewise, there are pros and cons. But I agree, there should be checks and balances, because judiciary independent, then executive and legislation, they work together. But in that case, no one can interfere. So that's why these type of provision should come, references. If anyone appeal, even in any country, even after the highest court even confirm the high court decision, that is a conviction. But sometimes, according to our human rights and international human rights conventions, we have to see also once again how it give a, some type of, supporting for this type of thing. So that's why this section is there. That's why the references should come. So in that case, my argument is basically building up. There must be some viable, rather than this 20th amendment. We can change that, and we can see some principle. Principle, sometimes people may not agree, but to see the decision of the president rather than the president's decision, I mean, sometimes we have to see facts of the case. Otherwise, all these governments may not implement this. So then we see another argument. United Nations Human Rights Council, they can come with a special session and say, President pardon, remove from all the constitutions, if they don't like it. That also have not happened. The countries can decide according to their socio-economic, cultural, aspects, which is coming from the king's period, not only now. So these are the versions. A lot of arguments are there. I agree with that. So how can you pull together all this argument and build one? That is where you asked me, checks and balances. So that's why most of the countries, they refer that to retired judges to look once again and make a reference. So the president is not bound by that reference in any country, but the president can go through and see how it affects his decision.
Professor, again, multiple questions that I'm getting. A quick answer here, Professor. Would you say that the president, or writing to the president, or writing to a separate office that is created for pardons, would be, we consider the Supreme Court to be the final appellate court.
Yeah.
We consider that place to be the final. Would this be a pseudo-final sort of appeal that we can make towards the president? Is that the process that has been created? Is that something that we can tell people?
Actually, it is not an appeal. It is not an appeal. It is where the prisoner itself making a request. So when prisoner making the request, once again, I go back to the prison ordinance. There is a, humanity ground, I feel. All prisoners are also humans. So it is not challenging the courts. If it is challenging the courts, why many countries, even France, if you see, in France, the constitution allowed the president to give pardon, fully or partial. So then this question may not arise what you are asking. So then Sri Lanka must be the one and only country which is basically following all these rules. No. So you have to see the contemporary, even in India, even in Nepal, even in Bangladesh, how this works. So when a president pardon given, most of the time they take this as a political issue. I am not going into that extent. I don't mind A or B or C or D. I am just explaining the procedure. So, next United Nations Human Rights Council, one country can make or pass a resolution, remove president pardon from the constitution. No, it will never happen. Even in United Kingdom, they don't have a written constitution. But even I can give few cases where they have considered that. So then your argument is you should not consider it is actually challenging the independence of the courts. So that's why there is a bridge. You have to, bridge. But in Supreme, you see in United Kingdom, lords are there. So they are also part and parcel of the parliament. Lord Denning and others. So they can look into in a different way. This is not a challenge, or this is not basically, going against the courts, but if a request made, they can consider it.
Professor, just to end our segment with two questions. You said something very important about post-judicial review, a word that I also was not familiar with until I spoke to you, something our viewers would also very much like to hear. Before that, Professor, since you did touch on the United Kingdom, and we also follow the United Kingdom system to a large extent, are they the people we should be getting the or the president from, or if we are going to refer to another country, is that the most supreme sort of, let's say, authority that we should be taking, or is there another country that we should consider?
No. If it is a Westminster Parliament, like 1972 Constitution, we should refer to United Kingdom. I will give two countries. Just follow USA procedure and the USA system, and also France. You can check the constitution of France, and we can make certain type of, exemplary provisions for this. But I want to reiterate once again, even the USA have this, pardon attorneys, office of the pardon attorney. Most of the president has bypassed that. So this is where even in USA Supreme Court, little bit reluctant to, go through or even review the president's decision. They think it's a president's decision. That's why I give the best example, Richard Nixon, president. He was punished by impeachment, but he was given the president pardon in a later stage. Right. My argument is this: there can be certain type of, other reasons also behind this. So in those cases, the best is, rather than India, take the USA and
French.
Those two constitutions go together with that.
All right. Professor, just to get a final word in, I just want your views on post-judicial review. How will that work in this sort of scenario, Professor? Will that work as an additional level to checks and balances? Can we implement that as a last question before we end the program?
Now, judicial review power is there in many countries when it comes to these constitutional matters and also the acts and the regulations. So we can't question anything. That is where you go with the judicial review. But post-judicial review power also important. Even if it is basically given by 2 judges in the Supreme Court, you can refer into 5 judges. Likewise. But when you come to the pardon, once again I am telling, it is not an appeal.
There is no requirement also.
Yes, it is not an appeal.
Yeah.
But when you request, you can see those who served in the US like judges, they look into that in a different way. So even in many European Union member countries, Germany and other countries, what they also do, they are not referring to sitting judges or tried judges. They refer that to a retired Supreme Court or highest court judges. I think we should, look into a system like that because they know the procedure well.
All right. Professor Prathiba Mahanamahewa, thank you so much for joining us. I believe you shed light on a lot of contemporary subjects, that a lot of discussion that people are having. Really clarified those legal questions for them. Thank you so much for joining us, sir. I would like to thank our viewers for joining us. Join us again next week when we bring together another weekly topic that is pertinent to the legal atmosphere within Sri Lanka. This has been Law, Land and Liberty. I'm Dhanvi Tanwasam. Have a great night.